welcome. We had reached the point of the Magna Carta Society expressing serious alarm at the overreaching of Parliament and the diminution of powers with or without her connivance of the Queen. In formulating a plan to go forward, the Society referred to Winston Churchill's book, The History of the English-Speaking Peoples, in which he said, when talking of the Magna Carta, quote, "And when in subsequent ages the state, swollen with its own authority, has attempted to ride roughshod over the rights and liberties of the subject, it is to this doctrine that appeal has again and again been made, and never as yet without success." End quote. The Magna Carta Society and at least tens of thousands of others believed that the time was indeed overdue to put the great principles and rights enshrined in the Constitution to the test once again. As they said, eventually the EU's right to rule over the United Kingdom must be tested in the highest court in the land, especially given the speed, comprehensiveness and destructiveness of the EU legislation. The Society identified a second front developing in the battle over the Constitution, which was the dismantling of Britain's and the Commonwealth's parliamentary institutions and what they called a cavalier disregard for our Constitution and rights. The Magna Carta Society began its summary of their submission with the observation that the overall weight of the extracts of law and precedent already explained gave, quote, "good reason to believe that under Magna Carta, 25 hereditary peers can convene themselves as a quorum and sit as a House of Lords, despite a recent bill purporting to restrict its hereditary numbers," end quote. They had, they stated, reason to believe that such a quorum could be assembled, and further, that under the terms of Magna Carta, that House has an obligation to hear petitions brought by free men and take them to the Queen, who was equally obliged to hear them. This, the Society contended, is the ultimate consequence of the unique contract established under Magna Carta and renewed at each coronation. To those in the government and judiciary who might argue that such rights of appeal no longer existed, the Society proposed several cogent questions. When do they claim that right was taken away? By whom and how? On whose authority? And by what right? The Society pointed out that the last monarch to receive such a petition was Queen Victoria, and could find no evidence of any attempt to prevent or hinder any such petition since. They also could not find any legislation which attempted to defy the contract made between the sovereign and the subjects in Magna Carta and the coronation oath. They acknowledged that the recent custom had become for petitions to be passed to ministers of the Crown for action. But that didn't preclude the monarch from acting in their own right. They also pointed out that in the present circumstances, the ministers were a party to the complaint, so therefore could not properly deal with the matters at issue. In any case, they pointed out, the sovereign can't be absolved from her responsibilities, and certainly not on the mere advice of ministers, or else the coronation oath would be meaningless. They then stated to Llewellyn Price QC that they were preparing a petition for submission to the hereditary House of Lords for presentation to the Queen, based on the following terms. "We, the undersigned, seek to draw attention to and seek redress from the imposition of foreign laws, directives, regulations and judicial decisions by and from the European Union and its institutions, to the detriment and prejudice of your sovereignty and our rights and freedoms, as defined in Magna Carta, the Declaration of Rights, and the customs of your people, and which you, our sovereign, swore to uphold and preserve inviolate in your coronation oath of 1953." End quote. They stated that if Magna Carta stands, they have a right to enter such a petition, and that if it does not, then the kingdom itself stands in great peril. The executive have some momentous questions to answer, and all free men of the kingdom need to hear the call. They stated firmly that Magna Carta or not, action is needed, and they were intending to take it. That completed the basic submission to Leland Price QC, but the document continues to discuss various other questions that would arise depending on the success or otherwise of the Society's actions. Although the objective of this document had been to make a case for the constitutional repudiation of the United Kingdom's membership of the European Union, the Society noted that there were other means possible to achieve the same end. For example, the government of the day might withdraw. The EU might throw the UK out, with a tongue-in-cheek reference to how lucky that would be. Parliament might vote for the repeal of the 1972 Act. Private prosecutions of government ministers for treason might be successful. Any of these would have much the same effect as that being sought. Nevertheless, the Magna Carta Society stated there were other actions which could be taken, some legal, others administrative, which needed urgent attention. They listed 11 of them. 1. Determine how best to test in the courts the claim that European law is supreme in the UK. 2. Examine the direct conflict taken between the oaths sworn by Privy Councillors and EU Commissioners. At the very least, the Magna Carta Society advocated the public stripping of their status as Privy Councillors, all those who had taken the Commission's euro. 3. Examine the constitutionality of Parliament's attempts to interfere at the EU's and European Court of Justice's insistence with the oaths of attestation made by all the armed forces. The upshot of these actions indicates Parliament exceeding its authority and compromising the sovereignty of the Queen. 4. Examine the issue of citizenship stipulated under Article 8 of the Maastricht Treaty. British citizenship, more correctly defined as being subject to the Crown, is a birthright, not bestowed by any authority, least of all a foreign one, which is not accountable to the British electorate. Citizenship in such an institution has no constitutional standing in Britain. Further, the concept of dual citizenship is a matter of individual choice. The European Union is not even a state, so how is it possible to be the citizen of a non-state? Such nonsensical notions need to be dealt with by the courts. 5. Examine the constitutionality of the 1975 referendum and the proposed one re-adoption of the euro. Both these appear to be forbidden under the Constitution, and proceedings may need to be instigated to set them aside. 6. Investigate potential cases for treason against all the plenipotentiaries acting under the royal prerogative and who signed the treaties of Rome, Maastricht and Amsterdam on behalf of the United Kingdom. 7. Test the legality of all new EU directives, legislation and regulations as attempts are made to enforce them. Issues to be resolved include the euro, tax harmonisation, weights and measures, a European Defence Force, Europol and Corpus Juris. as the EU attempts to enforce its policies and law on the UK, contrary to Magna Carta and the Declaration of Rights and common law, each and every one must be disputed to the utmost of individual Britain's power and resources. 8, 9 and 10 deal with issues arising post-membership of the European Union. 8 notes that the restitution of the Constitution will involve an avalanche of cases involving maladministration, covering many industries. Fishing is given as an example, with damage done to thousands of individuals and businesses over many years. Masses of illegal regulations will need to be abolished. Initially, a cessation or moratorium on enforcement seems the most practical and desirable step. How will the enormous issues of compensation be administered without tying up the courts for decades in legal wrangling? It would seem, says the Magna Carta Society, that justice would demand the state footing the bill. But that, of course, simply translates into the public paying through extra taxes and charges, since the state has no money of its own. Apart from Crown possessions, which are indeed stipulated in Article 61 of Magna Carta as legitimate sources of redress until completion of the process. 9. Investigate potential cases of treason against all Prime Ministers since 1972. 10. Investigate with a view to prosecution the past actions of ministers and officials who have exceeded the authority delegated to them by the people and who attempted to defy the clear intentions of the Constitution of the United Kingdom. And finally, 11. The people are sovereign, and the monarch is the embodiment of that sovereignty. It has been thus, and so it should remain. But these tenets of the Constitution have been seriously threatened by the erosion of the checks and balances between the sovereign, the Houses of Parliament, and the people. This erosion has been lengthy and insidious, and allowed to thrive by the negligence of the people who have failed to exercise sufficient vigilance. 473 years passed from Magna Carta until a further treaty was required to re-establish the relationship between the sovereign and the people, and even that Declaration of Rights was contaminated with seeds of treason and the abuse of natural rights. It had been 312 years since that latter treaty, which, as we have seen, has been breached not only by Parliament and the monarch, but even the judiciary. The Magna Carta Society expressed a strongly voiced opinion that it was time for another treaty to re-establish anew the true relationship between the monarch and the people. It should restate that relationship and restore the checks and balances between the monarch, the two Houses of Parliament, and the people, and reaffirm the covenant between the monarch and the subjects. In their words, quote, "Nothing else will do," end quote. This momentous document was researched and written by members of the Magna Carta Society on the 25th of January 2000. It was signed by these founding members: David Bourne, Mike Burke, Idris Francis, Adam Hartman, John Hurst, Bob Lomas, Brian Mooney, Ashley Moat, Bob Sims, and Brian Smalley, to whom, it must be said, every Commonwealth subject owes an immense debt, because 2 days short of 14 months later, on the 23rd of March 2001, Article 61 was indeed invoked, according to correct British constitutional protocols, opening the way for all people to lawfully dissent from this insidious treason and hold to account those responsible. The decision of the criminals involved in the deception to intensify their feloniousness by striving to keep this knowledge from the public only magnifies their karmic debt to those they have sworn so faithlessly to serve. When one considers the immense damage done not only to individuals, but to the very fabric of a society founded on the concept of universal morality, it's easy to see why treason has always been, and remains despite an illegal attempt to abolish the ultimate penalty by the Blair government in 1997, a capital crime. It is truly, as defined by Cicero, an attempt to bring about the death of an entire nation, or in this case, an entire family of nations, which it does by entangling an ever-growing number of individuals in interlocking webs of corruption and misery. Next time, we turn our attention to debunking the fallacy and falsehood of the sovereign citizen accusation being levied at some of those standing as law-abiding subjects under the Constitution. Thank you for watching.